can provide a fair and impartial jury, just Fremont County. And so where this poll has all these other results from other counties, almost 90% of the results are from other counties. And it's not divvied out by county. This poll is irrelevant this survey and report are irrelevant to today's proceedings.
Right,
also, this poll does not meet the standards met and Mr. Pryor has not even made an effort to lay the foundation required by Pittsburgh Press Club versus United States. So there's also a foundation objection.
All right, your response to those objections, Mr. Pryor.
Judge, to suggest that I'm supposed to limit my survey to one particular county is ridiculous. And to suggest if he wants to make the argument that because Fremont was only a portion of this survey, that the results are invalid, I'll be dealing that with Mr. Bryant. As far as the Pittsburgh case that he refers to, Judge, the survey, if you read the case, it says that the attorney is involved in the actual polling. The attorney's intimately involved in the case. To suggest that Mr. Means or myself cannot make suggestions to Mr. Bryant in terms of what areas we would like to explore for purposes of a survey is absolutely ridiculous. And Mr. Bryant's going to address those.
All right, there's a pending objection. Counsel, I'm going to take this under advisement for just a minute and review that case. I've seen the case, but I haven't read it recently. So I'm going to take a moment, take a look at that. After I've reviewed that case, I'll come back on and make a ruling on the objection as to foundation. All right, counsel, we'll be back on the record here. The court has considered an objection to the admission of defendants exhibit 10. The state cited the Pittsburgh Press Club case. Courts reviewed that, which raises the issue of whether or not a survey would be admissible if it is material, if it's more probative on an issue than other evidence and has circumstantial guarantees of trustworthiness equivalent to those of the class exceptions they talked about in that case. And then the proponent of admitting that has the burden of establishing the elements of the admissibility. So at this point, the objection was based on relevance and foundation. On the relevance issue, I do find that for purposes of this hearing, there's been a foundation, it's been established that it may be relevant, subject, of course, to cross-examination if Mr. Wood believes there's issues with the way it was conducted. In terms of the foundation, at this point, I would indicate, Mr. Pryor, I don't believe there's been a sufficient foundation laid for the admission of that, but I'll allow additional foundational questions if you have those from your witness before making a final ruling.
Okay. And Mr. Bryant, I want to start again. Can you hear me, sir?
Yes. Can you hear me?
Yes. So at this point, the survey that was conducted by your organization was done in the ordinary course of your business from your company. Is that correct?
Yes.
And nothing deviated from the standard procedures that you applied and the standards that are set out by your trade and organization. Is that correct?
Correct.
And you conducted the survey. Now, in regards to the questions, ultimately, Mr. Means did provide you some suggestions, but ultimately you formatted and put together all the questions yourself through your organization. Is that right?
Yes.
And then those questions were transmitted out on a variety of medium. Is that correct?
Correct. Both. We conducted the survey by telephone and by internet, by an invite to a web survey.
Now, based on the size of this survey, and before we get into that, when we're talking about the percentage of error or the percentage that would apply to a particular survey such as this, how much of a percentage of error or a deviation is there on a survey such as this?
The traditional explanation in a beginning statistics class is you assume that responses are 50-50, 50% said yes to this or 50% said no. So based on that 50-50, we had a total of 177 completed surveys, which yields a sampling error of plus or minus 7.3%. That table is actually included at the end of the report. As you move towards further extremes, as numbers become 60-40, 70-30, 80-20, and so on, then that sampling error becomes smaller and smaller.
Well, that brings up an interesting point, is that part of the questions and part of this survey was to decide and find out what people's feelings were regarding the Chad Daybell, Lori Vallow case, correct?
Yes.
And one of the questions, obviously, was whether or not people in the survey thought that Mr. Daybell or Ms. Vallow were guilty. Is that correct?
Correct.
And the percentage.
Objection, we're getting into the substance of the poll without it being properly admitted.
I don't need to admit it yet.
Well, if we're going to testify off of it and the results, then it's been offered and we need to get a ruling on the admissibility. So I've allowed for additional foundation. Do you have any additional argument on the objection to the admission of that survey, Mr. Wood?
Yes, Your Honor. There are 7 factors that Pittsburgh requires. So far, Mr. Pryor I do believe he has established Mr. Bryant as an expert. However, he has not met any of the other requirements. In fact, he has, I would argue, actually gone against some of those requirements. And so we still object. He has not laid the proper foundation for this poll or the results to be admitted into court.
All right. At this point, I have considered that objection in light of that Pittsburgh Press Club case. I would note that The question here is not ultimate admissibility at trial for either a jury or a court to consider on the ultimate issue that may go to the results of the survey, as was the case in there. This is a hearing as it relates to argument regarding publicity in a venue motion. And so based on the context of where we are, the court does find that for purposes of this hearing only, the survey will be admissible, of course, subject to cross-examination, Mr. Wood, if you have an issue with the way it was conducted. So the court will allow the admission of exhibit number 10, and that will be admitted into the record.
Thank you, Judge. May I continue?
You may.
And Mr. Bryant, so we were on the subject, I'm sorry, I just had a hesitation there. Mr. Bryant, we were on the subject of the survey that was conducted in this particular case. And one of the areas of the survey addressed the issue of whether or not the people who responded to the survey felt that Mr. Daybell or Ms. Vallow were guilty. And can you talk a little bit about the response that you elicited from the survey?
Yes, the specific wording of the question was, and this is question 9, if you were to say you lean one way or the other right now about the guilt or innocence of Lori Vallow Daybell and Chad Daybell, which way would you lean? Now, from the 177 respondents, we had 82.4% said they were guilty.
Okay.
And only one person said they were innocent. We had a very, we had 3.4% said they were innocent until proven guilty, and 11.4% said that they needed more information before they were able to answer the question.
Okay. Now, in applying the margin of error on this particular question, 82%, what is the range of possibility? You had previously discussed that as you get higher up in the level of percentage. Now, we're talking a situation where 8 out of 10 people from Madison, Fremont, Bonneville, and Jefferson County determined 80% of those people in the survey from those particular counties determined that Mr. Daybell and Ms. Vallow were guilty. What's the margin of error? How high could that number actually be, given the margin of error that you would, from your experience, apply in this particular case?
Your Honor, I'm going to object to relevance where, again, this doesn't just apply to Fremont County, and we're dealing with multiple other counties.
Judge, you've already ruled on that. Can I go forward, please?
I'll overrule that objection. Go ahead.
Again, sir, what is the margin of error when we're talking about 8 out of 10 people, more than 8 out of 10 people already determining in this particular district that Mr. Daybell is guilty? What's the margin of error, sir?
5.8%.
So if we apply the 5.8 to the 82 point, what percent?
82.4.
Now my math may be a little off, but I come up with 88% given the high end of the margin of error. Is that fair?
Sure.
Okay. Well, 5.8 plus 8.4 is
Well, 82.4 plus 5.8, yes.
In north of 88% of the people believing that Mr. Daybell is guilty. Is that fair?
Yes, but it also goes the other way. It goes.
And I'm going to talk about that. It can go the other way as well. It could go down to 77 or 76 something percent, correct?
Correct.
Now, in your experience, and you talked about over 40 years doing this, how often have you run into a poll that was so slanted in one particular direction?
Well, it does occur. If you ask someone how satisfied they are with their new car, 82% might say they're very satisfied with their car. In this case, this is a very large percentage of people who believe that Lori Vallow Daybell and Chad Daybell, well, they lean towards their guilt.
Okay. Now it's
a very high percentage, yes.
So this is, you would consider this a very high percentage?
Yes.
Okay. Now, one of the other questions applied to whether or not Ms. Vallow and Mr. Daybell could get a fair trial, correct?
Correct.
Now, taking into consideration that over 82% believe that Mr. Daybell is guilty, one of the other questions you asked is whether or not he could get a fair trial. what were the responses in regard to that?
Well, we had 22.6% said that they definitely will receive a fair trial in Fremont, Madison, Bonneville, or Jefferson County. And an additional 37.3% said that they probably will, which is a total of 59.9%, almost 60%, or 6 out of 10 respondents felt that they would receive a fair trial in one of those 4 counties.
Okay. So I'm a bit confused. 82% say that he's guilty, but in spite of being guilty, he'll still get a fair trial. Is that what the polling seems to suggest from the folks in Jefferson, Fremont, Madison, and Bonneville County?
Correct.
Okay. Now I want to talk about particulars by way of county, and Mr. Wood brought this up. What are the percentage of respondents from Bonneville County?
55.4% of all the respondents were from Bonneville. Obviously, that's where we were able to get the most respondents.
And obviously that's a significant population in Bonneville County as well, correct?
Correct.
We're talking somewhere around 120,000 plus people, correct?
I can't verify that. Sorry, I didn't verify those numbers before getting on this.
And obviously, if you're talking about Boise, you're talking about a market in, it's not as big of a market as you would find 500,000 people in the Boise market, correct?
Well, that's correct.
Objection assumes facts, not in evidence.
Sustained. I'll strike that answer.
Okay. So at this point, what were the percentage of Fremont County?
We were only able to obtain 10.2% of our 177 respondents. So about 18 people were from Fremont County.
Does that change your factors in terms of the margin of error any?
Well, not on the overall survey responses of 177, no, but if we had to just analyze the 18 people in Fremont County, yes, it would create very large sampling errors.
Right, right. So the idea is not just to limit yourself to Fremont County. The idea is to get an overbroad spectrum of people from a variety of areas to get a more accurate polling of what people's beliefs are. Would that be fair?
Yes.
Okay, so what did we do in Jefferson County? How many people over there?
Well, we received 15.8%, about almost 16% of our 177 are there in Jefferson County.
And then how about Madison County?
18.6%.
Okay, so the people as a result of this survey were predominantly from Bonneville County, is that correct?
Correct. Well,
And
over 50% from
Right.
all 4 counties came from that one county.
Right. So predominantly the idea here, and obviously you're the expert in this, is to draw from a large swath of people to get a more accurate representation of how people in Eastern Idaho feel about Mr. Daybell and Ms. Vallow. Would that be fair?
Well, that was the objective, yes, to collect information from all 4 of those counties.
And the cumulative information only provides at 80%, all of the cumulative counties and the information that was obtained provides a margin of error of just a little over 5% then, is that correct?
Well, on that one question where it's 82% who said yes, they leaned towards the defendants being guilty.
Right, okay. Judge, I don't have any further questions. I'll defer to counsel at this point.
All right, Mr. Wood, cross-examination.
Thank you, Your Honor. Mr. Bryant, thanks for being here. I want to talk about the universe you chose to conduct your poll. You did state, correct, that your participants needed to be at least 18 years of age, and either have a valid driver's license or be a registered voter in Idaho living in Bonneville, Fremont, Jefferson, and Madison counties, correct?
Correct.
And you did that to make sure that the people you polled were potential jurors, correct?
Correct.
Okay. Now, I want to talk about, you said Mr. Means gave you suggestions on questions.
Yes, I wrote the question, and I have to tell you, Thank you for asking that. The one big change that Mr. Means gave is he wanted to make sure that the word Vallow was included in Lori Vallow Daybell's name.
Okay, but so he did participate at some level in the creation of the questions.
Yes, I did not include Vallow in Lori Daybell's name.
And did he make any other suggestions to you?
I don't recall that he did, no.
Okay. I want to talk about your representative sample. You've said that 10.2% of the individuals polled came from Fremont County, correct?
Correct.
And that, according to my math, is about 18 people. Is that correct?
Yes, I actually have the numbers right here. Actual numbers, if you don't mind.
That would be great.
We actually have achieved 98 out of Bonneville, 18 out of Fremont, 28 out of Jefferson, and 33 out of Madison. I can repeat those if you need me to.
I've got it. Thank you. You've been conducting surveys and polls for, you said, approximately 40 years.
Correct.
How many times have you polled as to the guilt of a criminal defendant in an area where a juror could be called?
Twice before.
Twice before. So this isn't done regularly, is it?
No, I have to admit, most of my research is in healthcare, public policy.
Okay. And so in doing your poll, let me ask you this. Are you familiar with, did you study any census numbers to get the relative populations of the counties you polled?
No.
Okay. And you said that you sent an invite out for the poll online. Is that accurate?
Correct.
And so, and how did people respond to that? What was the methodology for sending that out, and how did people respond to it?
We contract with a sampling firm, specifically Dynata, which is one of the largest in the United States. They're based out of Provo, Utah. And Dynata, we requested panel sample meeting. We identified the criteria of over a certain age, driver's license, registered voter in those 4 counties. They told us how many they had where they had email addresses, and they told us how many they would have where they had telephone numbers. So when they had email addresses, we sent them an invite indicating that we were conducting a poll with residents in those 4 counties. And if we were able to get a response by web via an online survey, then we collected those. If we had both an email address and a telephone number, and they did not respond to the web invite, we then followed up with a telephone call. If all we had was a telephone number, then we started out conducting by making telephone calls.
Okay. In the email that was sent out, did it identify what the subject of the poll was?
Yes.
Okay. So someone who is interested in that issue might be more likely to take that poll, correct?
That's correct.
Okay.
I mean, we did not say it was a murder trial in eastern Idaho. We just said we're interested in your opinion about a local court case that you may or may not have heard of.
Okay, so it didn't identify it by the words Vallow or Daybell?
No.
Okay. All right. So let's get to, we're here today, Mr. Bryant, to determine if jurors in Fremont County are able to be unbiased in a jury trial. And so as I look at your poll, I cannot read this and get information specifically about jurors in Fremont County, correct?
That is correct. Because we were request. I'm sorry to interrupt, but we were requested specifically by Mr. Means to conduct the survey in all 4 counties.
All right. And he did not request that you divvy that up county by county, correct?
That's correct.
Okay. And so if I want to know, if I want to poll and survey potential jurors in Fremont County, well, strike that. Did you do any type of county to county comparison in the numbers you received?
No, I was not requested to do that.
Okay. And I think you testified earlier, you're not familiar with the population size of Fremont County, correct?
Correct.
Okay. Really quick, was this poll conducted, do you know if it was conducted on behalf of Lori Vallow Daybell or Lori Vallow Daybell and Chad Daybell?
Wow, my understanding is that it was being conducted on behalf of both.
Okay.
That's my understanding.
Okay. And when you asked the questions in your poll about guilt, say question 9, you didn't separate Lori Vallow and Chad Daybell, did you?
No.
So again, and sorry, I kind of got off on a little bit of a tangent there, but if I want to, again, I can't look at this poll and know and separate information about Fremont County without it being combined with information from those other 3 counties.
Well, I could do that, but given that we only have 18 respondents from that county, your sampling error is going to be huge. And I usually, as a rule of thumb, we don't put forth results for just anything under 25 respondents. And with only 18 in that particular county, the numbers would have very large sampling errors.
Okay. And so would you agree with me that 18 individuals is a very small amount of individuals to poll on an issue like this?
Well, if I'm looking at just that one particular county, yes, but the objectives that were given to us from the research specifications were not to just survey just one county.
Sure, and I understand that. And the questions I'm asking are not necessarily what you were asked to do. We understand you were given a commission and that you followed that commission. I'm not questioning that. It's the applicability to Fremont County.
Well, with only 18 respondents, I would not apply the results from those 18 respondents to reflect the entire opinion of residents in Fremont County.
Thank you. I have just a couple more quick questions. I would note that your question 1, it reads, are you familiar with any crimes that happened in the Rexburg area over the last couple of years where 2 or more people were killed? That's the question, correct?
Yes.
And you would agree, would you not, that the moment you say the word crime, you imply that someone's guilty, correct? Because crimes don't commit themselves.
Well, you're getting into semantics here, Mr. Wood. I guess
Okay.
that's the language I put in the questionnaire, and
Okay.
nobody objected.
Did you ever ask anybody if they believed that individuals are entitled to a presumption of innocence before proven guilty?
No, that was not the objective. However, we did have that as a response category that had been assigned to question 9. When you're reading just for clarification, when you're doing a web survey, these were all what we call closed-ended questions. And so when someone saw the question 9, if you were to say you lean one way or the other, about the guilt or innocence of Lori Vallow Daybell and Chad Daybell, which way would you lean? All the respondents saw the possible responses of guilty, innocent, innocent until proven guilty, and need more information before answering. And they had the option of saying, I don't know. So they saw those on the screen as they were conducting the survey. Similarly, if they participated in the survey via the telephone, the interviewer read those response categories to the respondent. And so there again, they heard the words innocent until proven guilty.
Okay.
Did that answer your question?
Somewhat.
Not exactly.
I understand a little more how the poll was conducted now. Based on the way these questions were asked, would you be able to separate out the bias against Chad Daybell as opposed to Lori Vallow Daybell?
No.
Okay.
I'm sorry. Yeah, the only thing that gets to that is we have, we have questions 3 and 4. Question 3, do you remember any details about this crime or the people involved? That was an open-ended question. So we didn't give them any names, but, and so you can see in question 3, 39.2% mentioned Lori Vallow Daybell, 35.2% mentioned Chad Daybell. Those are what we call open-ended questions. I didn't give them a list of options to select from. People mentioned Lori Vallow Daybell or Chad Daybell.
Okay. Now, based on your answer that you can't separate the bias totally between Mr. Daybell and Mrs. Vallow Daybell, is it also fair to say you cannot separate the bias between Mr. Daybell and Mrs. Vallow Daybell in Fremont County?
Oh, definitely not. Not from only 18 respondents, no.
So, Mr. Bryant, with the way you're answering these questions, if you were to conduct a poll for the purposes of finding if a jury could be pulled in Fremont County only, you would have wanted to question a lot more than 18 people, correct?
Well, I would have, yes. Statistical rigor, rules of APOR would have requested or would require that we had at least 100 completes just from that one county.
Okay. I just have just a couple more questions. Did you have any help in conducting the survey from people in your firm?
Absolutely, yes. I had a project manager. I had programmers who programmed the survey.
And would you consider those people that work with you to be experts?
Well, absolutely.
Okay, that suffices. I don't.
Yes.
Were you aware of the purpose of the litigation when you conducted your poll?
It was originally mentioned to us by Mr. Means that yes, this was specifically the Fremont change of venue survey.
Okay. And again, you testified earlier that you're not familiar with the United States Supreme Court case, Pittsburgh Press Club versus United States.
Judge,
No.
I'm going to object at this point. This court made a ruling on that issue, and Mr. Wood is just trying to relitigate an issue that this court already addressed.
Your Honor, I'm entitled to ask questions that go to the weight of the survey.
I'm making a ruling already, Mr. Wood. It's overruled. I think it is still relevant, so you can answer the question or you can re-ask it, Mr. Wood.
No, he did answer the question, if I'm correct, that he was aware of the purpose of the litigation, Your Honor.
And the question
the state this time has,
Mr. Wood, the question objected to is about the press club opinion. And I don't believe it was an answer.
well, He already testified to that, Your Honor. He wasn't aware of it. That's fine. At this time, the state has no further questions for Mr. Bryant. The state would make a second motion to exclude, though, based on Mr. Bryant's answers, that this poll for the purposes of Fremont County is simply not sufficient. I think he said he need 100 complete surveys, and there are only 18. So again, the state makes a second motion based on lack of relevance to exclude this poll.
All right, your response to that motion before we get into further redirect, Mr.
Yeah.
Pryor.
Judge, at this point, the survey was done in a 4-county area that included Fremont County. As a whole, and as a complete whole of 170 plus 77 responses, Mr. Bryant testified that the margin of error is 5.8%. So as a whole, in counties that include Fremont, in counties that include Madison, in counties that include Jefferson and Bonneville. Now, the allegations in this case rise out of both Madison and Fremont County. To have this court order myself or Mr. Means to do a survey in Fremont, then do a survey in Madison, then do a survey in Jefferson, and then do a survey in Bonneville would be prohibitive. So my feeling is if the court wants to apply whatever weight to this survey it wants to apply, that's the court's prerogative. And at this point, the relevant argument is inapplicable in this particular situation. It's clearly relevant.
All right, I've considered the state's second motion to exclude after the testimony of Mr. Bryant. The issue that's brought up for the court is the small number of Fremont County citizens that were polled as part of this polling, a total of 18. The issue before the court is whether or not a fair and impartial jury can be found within Fremont County. And for purposes of this hearing, which is what the Exhibit 10 is being proffered for, and the issue as it relates exclusively to Fremont County, the court does find, based on the responses of Mr. Bryant, that Exhibit 10 will not be considered both for lacking foundation and on relevance grounds, mostly based on his very candid testimony that he would not apply the results of the survey to Fremont County because the sampling error was too small and the margin of error would be potentially too large, and it would go against the standards of APOR, which are the standards he used to conduct the survey with a result of only 18 participants on the survey. So I think clearly, having heard those responses, the court can't consider this survey as it relates to finding potential jurors in Fremont County. So the court is going to sustain that motion offered by Mr. Wood, and the survey Exhibit 10, although previously admitted, will not be considered in the court's determination on the issue.
And Judge, in response to the court, if I may, if you look at my change of venue motion, I am asking to move from Fremont County, but I specifically in my motion address the issue as it relates to the 7th Judicial District that includes Madison, Jefferson, and Bonneville counties. My motion for change of venue specifically says that this hearing and this trial could not be effectively held in the 7th Judicial District. So I would ask the court to strongly reconsider its position as, although this is Fremont County, I think the court is splitting hairs by saying, yes, Fremont County, but frankly, I was also moving for the entire move from the 7th Judicial District. And under the rule, I'm permitted to seek a change from a particular judicial district. So at that point, based on how I've pled this in my pleadings, I think it is relevant.
Your Honor, I would just very quickly respond. This poll did not include all of the 7th Judicial District. It left out Bingham County, which is a fairly large county, and a couple other smaller counties. So the poll would still not be relevant.
Well, Judge, I don't have to go over every entire county to do this. What I do is I take the largest county within the 7th Judicial District, who happens to be Bonneville. I take the 2 counties that happen to be where a significant number of these allegations arise, and I take the adjoining Jefferson County. So when I pled this, I included the 7th Judicial District in my pleadings, and under the rule for a change of venue, a transfer, a trial, I am allowed to select and plead that this particular judicial district is not appropriate. So I renew my motion, Judge, and ask the court to reconsider and allow this exhibit to be admitted.
All right, well, I've considered the arguments on the admissibility of this Exhibit 10. I've also considered the change of venue motion itself and Criminal Rule 21. And still the question before the court today, while Rule 21 does contemplate whether transfers should occur within the district or outside of the district, and that's part of a determination, the first question the court has to cross as a threshold before getting there is whether or not we are transferring this trial out of the current location of Fremont County. And so the issue is whether or not we could find a fair and impartial jury in Fremont County. We haven't made a determination yet that it's being transferred within the district. If it were there, potentially this would be admissible, but where we are right now is trial located in Fremont County. The first judicial question I have to get to is whether or not we're going to go outside of Fremont County, and then we'd consider where an appropriate place would be, a different county. And so based on consideration of all that, still with those responses we have and only 18 people polled within Fremont County, the court's not going to change the decision I've made that Exhibit 10 will not be admitted or considered for purposes of this motion today. So that'll be my ruling, counsel.
And Judge, I guess in my position, simply if the court is excluding the report for purposes of Fremont County, at such time, if the court decides that Fremont County is not appropriate and is looking at whether or not the 7th Judicial District is relevant, at that point, this report does become relevant at that point.
Well, that is a potential, Mr. Pryor, because under Criminal Rule 21C, under Parts 1 and 2, there may be a determination made as to whether it should stay within the 7th District or without. And I would reconsider the ruling if we were looking at potentially moving within the district. So for purposes of where we're at today, I'm not considering it, but your point's well taken there.
All right, and Judge, so at this point, I would reserve my ability to seek a motion from the court asking that the court apply Mr. Bryant's report in the event the court moves this case from Fremont County, and it has to, at that point, under the rule, consider an appropriate judicial district.
All right, I'll just take that request under advisement at this time, depending on where we end up. So,
and I have nothing else for Mr. Bryant, Judge.
Okay, thank you, Mr. Bryant. Then that'll conclude your testimony this morning.
Thank you. I'm free to leave the Zoom meeting.
You are. You can log off.
Thank you, Judge.
Thank you. All right. Do you have another witness to call, Mr. Pryor?
I don't have witnesses, Judge, but this may be an opportune time to have a meeting to discuss my notebook and how I would present the remaining exhibits in a way that complies with the court's admonishment about unnecessary advertising. So I would like to have a brief discussion about how I intend to proceed with the remaining documents and then go forward from there if the court would accommodate that request.
All right. I think that that's a reasonable request. I think the time's good for that as well.
You know, I would ask though if we could take a brief 5 to 10 minute break before that.
Okay, so here's what we'll do. We'll take a break until 10:30, at which time I'll ask the clerk to please set up a breakout room where I'll meet privately with counsel. I will have the court reporter take a record of the proceedings of the breakout room, and we'll discuss potential exhibits to be admitted in furtherance of the motion. So we'll be in recess for 10 minutes, and then we'll reconvene in the breakout room.
Thank you.
Madam Clerk, do you have a way to message Mr. Pryor about exiting the breakout room?
I do, Your Honor, and I can just close the room and it'll stop in about a minute, so.
Okay, why don't you do that? Okay, we'll be back on the record here. We took up some evidentiary issues outside of the presence of the live recording here due to the potentially inflammatory nature of the proposed exhibits that were being offered. Court went through a motion regarding admission of certain exhibits and made a ruling on that. I will note on the record that we did have the court reporter there for those proceedings, and there will be a record of those proceedings, which were taken out not in the presence of the live recording. With that, then, the ruling the court made was as it relates to proposed exhibits that have been offered by the defense in support of the motion. Those are contained in a electronic folder that has 10 separate subfolders. The court admitted subfolders 1 through 8, with the exception of a photograph in subfolder 3 that was not admitted. On the other subfolders, those haven't been proffered yet. On number 10, that previously was the survey, the insight survey that the court ruled was inadmissible. So before the court then, which has been admitted, are the exhibits contained in those subfolders 1 through 8, with the exceptions I just mentioned. And the court made that ruling based on a self-authenticating analysis under Rule 902, subsection 6, and Idaho Rule of Evidence 101, F3. Also considering case law, the court considered including the Chiampi versus City of Palo Alto case 790 F supplement 1077, and in conjunction with the Idaho rules determined self-authentication for those published items. So those items will be considered by the court at this time as admitted. And again, any reference to those, if they're inflammatory in nature, Mr. Pryor, I'd require you to just refer to those in generalized terms, and I'll locate them on those drives. So that was the ruling on our evidentiary issue. With that in mind, then, Mr. Pryor, this is still your motion and your time to argue the motion. Do you have another witness you're going to call?
Judge, I have no further witnesses in light of the court's ruling admitting those 8 folders with the information that's contained within them. At this point, what I have left to do is make argument. So if the court wants to allow Mr. Wood to call his witnesses, then at the conclusion, if the court wants to proceed that way, I'll make my argument and obviously Mr. Wood's argument and my rebuttal, and we could wrap this hearing up if that's the way the court wants to proceed.
Mr. Wood, do you have witnesses you intend to call in objection?
Your Honor, we do have 2 witnesses. My suggestion would be that where it's noon, that we break for lunch and reconvene whenever the court says we should, and at which point our witnesses are ready and ready to go. But I do think now would be a good time to break for lunch.
Okay, I think that's a fair request at this point in the hearing and the proceedings, so we will break for lunch from 12 to 1. And I'd ask council to be ready to start up again at 1 o'clock, and we'll have your first witness then, Mr. Wood.
Thank you.
Thank you. We'll be in recess then for an hour.
So who are our two witnesses? He lives out by me. There's a kid
All right, I think we've got everyone here. Madam Reporter, are you ready?
Yes, Your Honor.
Okay, we'll go back on the record after the lunch break on this matter. This is the time for a change of venue motion. Case CR 2221-1623, State versus Chad Daybell. Counsel's present and appearing. At the time of the lunch break, we concluded with Mr. Pryor's presentation of evidence. And at this point, Mr. Wood, I understood the state had witnesses to call. Is that correct?
Yes, Your Honor. I'm not seeing them in this room. I don't know if they've been accepted yet.
Okay, who's your first witness are you intending to call?
Len Humphries.
All right, let's see if he's there.
Need to get logged in right now or wait?
It's like he's having an issue getting connected. Do you know where he's appearing from, Mr. Wood?
I believe his office, but I'm not sure, Your Honor.
Okay. I just wondered if he was there.
He's oh, there he is.
Good afternoon, Sheriff Humphries. Can you hear me okay?
Yes, Judge, I can.
Okay, thank you. Wanted to make sure you were properly connected. So, Mr. Wood, you may go ahead and call your first witness then.
And the state calls Sheriff Len Humphries.
All right, Mr. Humphries, or Sheriff Humphries, if you'd please raise your right hand, I'll have the clerk administer the oath.
You solemnly swear or affirm the testimony you will give in the pending cause will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Thank you. You can lower your hand, and counsel, you can inquire.
Thank you. Can you state your name for the record?
My name is Len Humphries,
Can you spell your last name for the record?
Humphries.
All right, and you said sheriff. Can you give us a little more background on that?
I am the Fremont County Sheriff. This is my 13th year as sheriff here in Fremont County.
Okay. So 13 years as sheriff in Fremont County. How long have you been involved in law enforcement?
Went to work here full time in 1988.
Okay. Today, what I need to ask you about, Sheriff, I want to talk about some of your responsibilities as it relates to the district court. Are you responsible for any actions connected to the district court proceedings and jury trials in your role as sheriff?
Yes, we're responsible for the security of the courts. We provide the bailiff services, security for the courthouse. We run the entries where people go through the magnetometers to make sure that there's no weapons. We're responsible for making sure that defendants are transported to and from court in a safe manner. We are also responsible for making sure the juries are safe, and witnesses that they are taken care of. We provide all of those services through the sheriff's office.
And Judge, in objection to where we may be going, I am concerned that the testimony is going to be focusing more on Mr. Wood's motion to impanel a jury than it is to address any concerns he may have about the change of venue. So I guess in the form of an objection, I'm deeply concerned that we're addressing the other issue and not the issue of how this affects a change of venue.
Well, there's been no question relating to that at this point, so that's premature, but I'll keep that in mind.
Thank you. And Your Honor, I would just note the state hasn't filed a motion to impanel a jury. So Sheriff Humphries, thank you for going over that. Are you also, you said you're responsible for the defendant's security. Are you responsible for housing the defendants?
Yes, we are.
Okay. And are you familiar with the case of the cases of Chad Daybell and Lori Vallow?
Yes, I am.
And are those defendants under your care and custody?
Chad Daybell in my jail here in Fremont County. Lori is in the Madison County Jail, who contracts with us to house our female inmates.
Okay, thank you. Now, the responsibility to cover court proceedings on crimes occurring in Madison County, does that responsibility exist wherever the case itself goes to trial?
I'm not sure I understand your question.
Okay, I'll rephrase it. I think I said Madison County, I meant Fremont County. So I apologize. If a case is a Fremont County case and a change of venue takes place and if that a case is heard elsewhere, do you still maintain the responsibility, the same responsibilities that you would maintain as if it were in Fremont County?
I believe that is the case, either by providing the staff to take care of it or contracting with the host county, wherever that may be.
Okay. Now, do you have a detectives division?
I'm sorry, once more?
Does the Fremont County Sheriff's Office have a detectives division?
Yes, I have 3.
Okay. And are you aware if they've been involved in the case involving Chad Daybell and Lori Vallow?
Yes, they have been involved.
Okay. I want to talk to you about kind of the monetary and manpower costs that arise if they have to travel outside of Fremont County.
Judge, I can object at this point. We're going into the motion of sequestering a jury and the costs that are associated with that. Mr. Wood can shake his head all he wants, but this is a backdoor way to address issues that I'm not prepared to address in terms of fixed costs. If the court's going to allow Mr. Wood to go into this avenue, then I want to be able to question this witness about all of the costs that are associated with bringing a jury from another county or otherwise, because that's exactly what he's trying to do here.
Well, it's overruled at this point. We'll see where the testimony goes on the issue. Of course, the matter before the court today is whether or not venue should be changed, meaning transfer the location of the trial. And I find this to be relevant testimony, so that's overruled. You can continue, Mr. Wood.
Thank you. If your detectives are subpoenaed to testify outside of your county, what are some of the costs that are associated with complying with that subpoena?
Judge, again, I'm going to renew my objection. This goes to the sequestering a jury and cost as it relates to that.
All right.
Your Honor, I'm not talking about
Third
sequestering
time,
a jury.
counsel. Yeah, I'm overruling the objection for a third time, Mr. Pryor. This is just in question as it relates to possible change of venue. So continue, Mr. Wood.
Thank you. Sheriff, do you recall the question, or do I need to ask it again?
As I recall, the question was the cost involved when deputies are subpoenaed outside of the county. Those costs would be travel costs, of course, per diem, for meals, lodging, overtime costs, possibly. The additional cost of having the deputies outside of the county means that the calls and work that they would normally be doing, I would have to have covered by other officers or have that work delayed until somebody was clear and able to take care of it.
Okay, so it's your testimony that if you had multiple detectives subpoenaed outside your county for a trial, and especially a lengthy trial, could that cause manpower issues for Fremont County detectives or Fremont County Sheriff's Office?
Yes, it would.
Okay. And is it fair to say that those detectives have more cases than the Vallow Daybell case?
Yes, that is fair.
Yeah. Now, at this time, can you put a dollar amount on how much it will cost Fremont County if your detectives are subpoenaed to testify outside of Fremont County?
Excuse me, Your Honor, I'm getting terrible feedback. I can't.
I'm hearing it too.
Yeah, so am I. I'm not sure where that would be coming from. Maybe Sheriff Humphries' microphone. I'm not sure.
I believe this is from Mr. Ward.
Yeah, it seems to be happening when I'm speaking part of the time.
Okay, hopefully we can figure out where that's coming from. I wasn't doing it before lunch, so I'm not sure why it would be doing it now.
Okay. Sheriff, do you need me to ask that question again?
Yes, please.
The question was, at this time, can you put a dollar amount on how much it will cost Fremont County if your detectives have to travel outside of Fremont County for if they're subpoenaed to testify at a trial?
There's no way that I could estimate what those costs would be without knowing where the trial might be held or how long the trial might last.
Okay. We've talked about your detectives being subpoenaed and what that would do to the detectives department. What are some other responsibilities you may have to provide in another county if a trial is moved?
I anticipate that the same costs would apply as far as providing security, providing transportation, providing housing for employees, as well as jurors, things like that.
Okay. Is it your opinion that trying these cases in Fremont County would be more economical for the Fremont County Sheriff's Department than having it tried in another county?
Judge, I'm going to object at this point. There hasn't been sufficient foundation to suggest. In fact, this witness said that without sitting down and knowing exactly where it would go, he can't make a determination of what the cost would be. So to allow him to speculate would be completely improper. And at this point, allowing this sheriff to make an assessment without knowing where the county that this thing will be moved to, or the additional costs that might be incurred. And again, I'll renew my objection that this actually goes to Mr. Wood's sequestration of a jury in another county. So if Mr. Humphries wants to come back and talk then, great. But at this point, allowing him to offer an opinion is highly improper.
Mr. Wood?
Your Honor, I think that the sheriff, first, we're not talking about sequestering a jury right now. That's completely separate than a change of venue and the costs that might be associated with it. In terms of what he can testify to, we've already established that, yes, he cannot give an exact dollar amount. However, I do think as the sheriff, he is qualified to testify about the extra expenses of providing these services outside of his own county.
And Judge, actually, this sheriff mentioned the cost of housing a jury, so he brought it up in his case in chief testimony. So again, there's been no specifics, and basically you're going to elicit an opinion from a guy whose qualifications are he's the sheriff without any factual basis for what that opinion is based on.
All right, well, I can consider the testimony for the weight of what it's worth based on the foundation, but I do find that under both Criminal Rule 21 and Title 19, Chapter 18, which discusses removal of an action before trial, that cost can be a consideration, so I do find it's relevant, and I'll overrule the objection so you can answer, Sheriff Humphries.
Would you repeat the question, please?
Yes, is it your opinion that trying the Chad Daybell case in Fremont County would be more economical for the sheriff's department than having it tried in another county?
I do believe it would be more economical to be tried here, yes.
And why is that?
We don't have the travel costs involved. We don't have the issues of providing services in a trial outside of the county, and also maintaining services that go on while this trial is going, the other services, the other duties that need to be carried out on a day-to-day basis.
Okay. And so just one last question. Do your duties in Fremont County cease if you have to provide those services in another county as well?
They do not cease. Those services still need to be provided here.
Okay. That's all the state has at this time, Your Honor.
All right, thank you, Mr. Pryor. Cross-examination.
And Sheriff Humphries, could you tell me how many employees you have within the sheriff department who are deputized?
Deputized, I have approximately 21 officers right now.
How many of them are involved in the Daybell case?
At least 3 that have been involved in the investigation.
So obviously you understand and would agree with me that you obviously don't want those 3 deputies who are involved in the Daybell case to perform the functions within the department. Would that be fair? In regards to security, in regards to transporting Mr. Daybell or otherwise, right?
So the 2 of those are detectives, and the 3rd is my patrol lieutenant, who was a prior detective and was very involved with this case.
All right, so the question, and if you would answer it, is simply that we don't want those 3 deputies involved in the day-to-day process of such as transporting witnesses, obviously guarding Mr. Daybell, because the potential for some sort of conflict arises at that point, right?
Yes, that's correct.
So we're down to approximately 17 or 18 deputies, correct?
Yes.
And how many deputies does it require you to maintain the jail on a daily basis?
I have 2 deputies on duty at all times in the jail.
Okay, and for how many in a given shift of 24 hours?
That would be 4, and 5 with the supervisor.
And it requires all 17 to provide appropriate supervision, or are you short manned within the sheriff's department in the jail?
No, we are fully staffed at this time.
Okay. So the question then would be, obviously, if anybody has any connection or any sort of link to the Daybell case, you obviously want to exclude them as part of the participating in the day-to-day activities of dealing with jurors, dealing with witnesses, and that sort of thing, correct?
Yes.
And it would be highly inappropriate for someone who has some sort of involvement, even a minimal amount of involvement, to allow themselves to inject themselves in the case, right?
Correct.
Objection goes beyond the scope.
Well, Judge, he's talking. Thank you. So, Sheriff Humphries, I do have a question for you. I'm looking at a June 11th of 2020 posting on your Facebook account. And on the Facebook account, it shows you retweeting pictures of a fence, some posters of JJ and Tylee. It looks like some pictures of a vigil, and there's some
Objection beyond the scope of the direct.
Judge, it goes to whether or not there's involvement by a police officer involved in this case. I have information that this officer is using his private Facebook account to make postings about this case, and further, that Mr. Wood is giving the thumbs up on these accounts.
So, objection
I
relevant.
think it's relevant.
Okay, the issue, underlying issue on change of venue is potential pretrial publicity or bias or prejudice that's come about to potential jurors because of that. And so as it goes to the underlying issue, I will allow for the line of questioning. But Mr. Pryor, I admonish you as previously, if it gets into anything that's inflammatory, I want to take that up outside of the live stream.
Okay, and I'm going to refrain from getting into terrible specifics about some of the things that you post. But Sheriff Humphries, quite frankly, how many times on your personal Facebook account did you post information or pictures about Chad Daybell or Lori Vallow?
I don't know what you're looking at. I would
Well, I
like,
don't care what I'm looking at. I'm asking you how many times you posted these things on your Facebook account.
Objection,
How many?
argumentative.
That is argumentative, Mr. Pryor. Allow an opportunity to respond before you just jump in like that. So Sheriff Humphries, if you'd respond and further elicit the question of when you said you don't know what he's talking about, what do you mean by that?
I don't recall having posted or forwarded anything showing that on my Facebook account.
Okay, so you have never posted anything on a Facebook account that shows Len Humphries?
Objection, he's
In regards
misstating
to the,
the
in
testimony.
regards to the, and if I could finish, Mr. Wood, in regards to the Daybell and Vallow case, is that your testimony, Sheriff?
I don't,
Objection asked and answered.
He hasn't
Overruled.
answered.
Go ahead and answer, Sheriff.
I don't recall having posted a forward that you have described.
Okay. So do you have access to your Facebook account, and have you deleted anything since June 11th of 2020? Because I'm looking at a Facebook posting with your name on it, dated June 11th of 2020, and it's your picture, and it's obvious that there are images on there that are regarding the Daybell case. Do you
And I'm gonna,
dispute? If I could finish, Mr. Wood, are you
I'll let you
disputing
finish.
that took place?
Your Honor, I'm going to object to the form of the question. I'm going to ask that we go into a breakout room, that Mr. Humphries be shown this exhibit rather than be browbeaten about something that he doesn't know what Mr. Pryor's talking about.
Do you have a copy of the posting you're concerned about, Mr. Pryor?
I have a copy of several postings, Judge, and if you want to go into a breakout room and have a shared screen, we can discuss all of them.
Well, I think that is appropriate for him to be able to
Okay.
view those versus testifying about them. So
Okay.
in order to avoid inflammatory material being broadcast in this proceeding, we still will be on the record. The court will consider sealing portions of the record if necessary. I'll conduct the further inquiry of the witness in regards to these Facebook posts in the breakout session, which will be still on the record with the court reporter. So Madam Clerk, if you'd set up the breakout room, we'll do that.
Your Honor, I just received a message from Mr. Wood that he's tried re-entering, and it sounds like maybe he wasn't able to get back in.
Okay, we'll give him a few minutes and hopefully when he logs back in, it'll
It
resolve.
looks like he's coming in now.
Okay, thank you. All right, hopefully the feedback issues resolved. You just want to say something, Mr. Wood, to test that out?
Checking. I'm not hearing any feedback now.
Yeah, I think it's better. So thanks for doing that. All right, at this point, Mr. Pryor, then you can continue your cross-examination of Sheriff Humphries.
And Sheriff Humphries, after we had an opportunity to go in the break room and you had a look at the Facebook posting, you will acknowledge that on your personal Facebook account on June 11th of 2020, you posted images and a story about the Chad Daybell, Lori Vallow case. Is that true?
I did on that date, yes.
Okay. Do you have any recollection, sir, of any other dates that you may have put on your personal Facebook account, images or stories about Chad Daybell and Lori Vallow?
I do not have any recollection of any others.
Is it possible there are others out there?
I don't believe so. I didn't remember having done this one, but I recognize it when I.
And this wasn't on the sheriff's website that this was posted on Facebook, was it?
That's correct.
This was on your personal website, correct? A personal Facebook account, correct?
That's correct.
How many followers do you have, sir?
I have no idea.
Okay, thousands?
I don't think so.
Okay, but you would agree with me as the sheriff of Fremont County, you have probably a significant following within the confines of Fremont County. Would you not agree with that?
Objection calls for speculation.
It calls for him to answer a question about his following in Fremont County.
The objection's overruled. And counsel, for both of you, if you make an objection, give me an opportunity to respond first. I may make a ruling without jumping in to counter that, or I may ask for additional input. So with that in mind, the objection's overruled. You can answer, Sheriff Humphries.
I don't know how many people follow my Facebook page.
Okay. Well, you agree with me that you know how Facebook works. You send an image out to the people who follow you. And not only does it go to the people that follow you, it goes to the people that are on their accounts as well. Does it not?
I couldn't answer as to how Facebook functions that way.
Are you aware that you and Mr. Wood are friends on Facebook?
I was not aware of that, no.
Okay. Do you dispute that you and Mr. Wood are friends on Facebook?
I don't know who all is listed as friends on my Facebook page. I don't spend very much time on there.
But you would agree with me that a sheriff who's involved in one of the biggest cases in the country on his personal Facebook account starts posting images as it relates to an investigation in his county. At the least, you would call that questionable conduct, wouldn't you, sir?
Objection calls for speculation.
Overruled on those grounds.
You would call that questionable conduct, wouldn't you, sir?
Objection argumentative.
Judge, you already ruled on it.
Well, that's sustained. It is argumentative.
Okay.
The questionable conduct also does not provide any guidance for the court.
Okay. So is it your position, Sheriff Humphries, that since you did do some postings and have commented on the Daybell case on your personal account, that you should be excluded in participating in decisions regarding Chad Daybell and his trial?
I make very few decisions regarding his trial.
Well, you posted something on your personal Facebook account about the case, sir, and you acknowledge that you did it. And at this point, you're telling me there's nothing else out there. That's yet to be seen. But at this point, don't you find it inappropriate that a sheriff investigating a criminal case of some notoriety is putting personal postings about the case on his Facebook to some of his friends within Fremont County? You don't see that as a problem, sir?
Objection, relevance beyond the scope, improper arguments. Argumentative.
Judge, it's actually proper. It goes to bias of this sheriff. He's posting things on his Facebook account and he's sitting there and saying, well, go ahead, Judge, I'm sorry.
Well, law enforcement typically can be biased when they're investigating cases. That's not grounds for this line of questioning. He's a law enforcement officer. It's a personal account. It wasn't posted on the sheriff's official website. The impact that may have on the issue of change of venue is all that the court's concerned about at this point. And I do find the line of questioning improper at this point, and I'm sustaining that objection by Mr. Wood. If you want to get to the relevance of how many people this may have affected in a potential jury pool, that's what the court's concerned with today, Mr. Pryor.
Right. And that's where I'm going, Judge, is that in Fremont County, you would agree with me, Sheriff Humphries, that Fremont County is a relatively rural county. Would you agree with that?
That's correct.
And you would agree with me that there's been a significant, in fact, a great amount of press coverage as it relates to this case, correct?
There has been.
And you would agree with me that the press coverage in Fremont County alone has been saturated with a variety of photos, videos, stories from East Idaho News and others, correct?
Numerous outlets.
Right. And you would agree in this small rural community with that amount of significant press coverage and a sheriff who's the county sheriff in that, you don't think that you posting things about the Vallow Daybell case has an impact on some of the citizens of Fremont County, Sheriff?
I don't know what impact would be I do not know what impact that would have.
Okay. But you would agree there'd be an impact, right?
There could be.
Okay. And you would agree that it was probably a bad choice to post things about Chad Daybell and Lori Vallow on your Facebook account. You'd agree with that, right?
I do agree with that.
Okay. So in other words, you were at least, and Sheriff, I don't want to berate you and beat you up, but it's not the point here. But what I'm concerned about is that Mr. Vallow or Miss Vallow and Mr. Daybell get a fair opportunity. And you would agree with me that the amount of publicity has been significant. And as the sheriff of this county, contributing to that, however it's gauged, only adds to the media attention and the postings that are increasing the amount of attention brought to this case in Fremont County. You'd agree with that, right?
Objection calls for speculation.
Overruled.
You would agree with that, Sheriff, correct?
I should not have done it. Yeah, correct.
Okay. And in all likelihood, your posting could have been a factor in at least swaying some people in Fremont County. We don't know how significant. It could be greatly significant or it could be de minimis. You'd agree with that, right?
Objection calls for speculation.
That's sustained.
Okay. But obviously there was an impact by your actions by putting that on your Facebook account, right?
Objection calls for speculation.
Well, it's asked and answered. So move on to another question, Mr. Pryor.
No, I think that's it, Judge. I'm fine. Thank you.
No more questions for the
No
witness?
more
then?
questions, Judge. Thank you.
All right, thank you. That'll conclude the cross-examination. Any redirect, Mr. Wood?
Just one moment, Your Honor. Just one. Sheriff Humphries, in the post that you saw, did you mention Lori Daybell or Chad Daybell?
I forwarded a post that I saw that,
Well, just answer the question. Did you use the names Lori Daybell or Chad Daybell?
no.
Okay, that's all I have, Your Honor.
All right. And with that, that'll conclude the testimony of Sheriff Humphries. Thanks for your appearance today. You can be excused. And Mr. Wood, if you have another witness, you can call them at this time.
Your Honor, the state calls Shane Turman.
The post that I saw that,
Is his last name Turner or Thurman?
Turman.
And how's that
I'll have him
spelled?
spell it.
Okay,
That's showing up as Turner. I'm not sure why.
okay. So it's Turman?
Yes.
All right, Mr. Turman, if you can unmute, please, and if you can get a video signal. There we go. If you would unmute your microphone, please.
Is that?
Okay. I do hear you. Not real loud. I think you might want to talk into your microphone for the questioning. Let me first ask you, is that the correct spelling of your name is listed on the screen there?
Yes, that's correct.
Okay. All right. Thank you, Officer Turman. At this point then, Mr. Wood, if you'd like to call that witness.
Thank you, Mr. Turman. Can you state your name and
He needs
spell
to
it
be
for the
placed,
record?
sorry, he needs to be placed under oath as well before. So, Officer Turman, if you'd please raise your right hand, I'll have Madam Clerk place you under oath.
You solemnly swear or affirm the testimony you will give in the pending cause will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Okay, thank you. You can inquire, Mr. Wood.
Thank you. Can you state your name for the record and spell your last name?
It's Shane Turman. Spelling of my last name is Turman.
Thank you. And what's your title?
I'm the Chief of Police for the city of Rexburg in the state of Idaho.
Okay. How long have you been the chief of the Rexburg Police?
10 years, and this December will be 11 years.
Okay. And how long have you worked for the Rexburg Police Department?
Approximately 33 years.
Okay. Have you ever served as a detective?
Yes, I have.
Okay. Are you familiar with the case regarding Lori Vallow Daybell and Chad Daybell?
Yes.
How have you been involved in that case?
Well, as the Chief of Police, I've known that it's been going on. My detectives that work here have been some of the key detectives in this case. And so as the Chief of Police, I've had to make funds available and see to their needs and staffing so that they could perform their duties in this investigation.
Okay. And so have you worked with your detectives and their involvement in this case?
Just getting updates from them. But I
Okay.
have investigation myself.
Okay, so you haven't investigated it, but what has your detectives division's involvement been in this case?
They've been involved in this case from basically day one. I believe it was starting November 1st of 2019 when we received a phone call from a detective in Gilbert, Arizona, asking us to look for a Jeep they believed that was involved in a possible crime down there.
Okay. And let me go back for just a second. How many detectives do you have in your detectives division?
I have 6.
Okay. And is that the current number?
That is the current number.
Okay. Have you had any detectives that have worked on this case that have since retired?
Yes, I've had one detective that, I've had two detectives retire since this case started, but one of them was really the only one that was working on it out of those two.
Okay. And as the chief, are you aware that the detectives who've worked on that case could be subpoenaed as witnesses to testify at trial?
Yes, I'm aware of that.
Okay. And I just want to ask you a few questions about if a change of venue in this case is granted and the trial is moved, what kind of cost does the Rexburg Police Department incur as a result of that?
Well, for instance, if we go to the city has a scale for per diem, and so we would have to pay per diem for each one of those detectives, along with depending on how far out it was. If it was a place where we'd have to get them a hotel room, we'd have to get each one of them a room. And for the city, roughly, it's about $71 a day per diem, going off of someplace like Boise, Ada County, most places.
Does that per diem amount change depending on where the location is?
It can, but the 71 is pretty close to most of the places in the state of Idaho.
Okay. So you mentioned per diem costs, you mentioned hotel costs. Are you responsible for their travel costs?
Yes. So we would pay for a hotel room for each one of those detectives plus their per diem.
Okay. Chief, of the detectives you have now, do you know how many of them have been significantly involved in the Daybell case?
Yes, I have 5 out of my 6 detectives that have been significantly involved.
Okay. And in the event they were subpoenaed for trial, and we don't know how long the trial would last, but I think we can assume it would last several weeks. What effect would that have on your detectives division in Rexburg?
Well, you know, the number one thing as the chief I'm responsible for is the protection of our citizens here. And, you know, we have a college with 22,000 students, and each one of those detectives is carrying a caseload, dealing with all kinds of different crimes. It would really hinder us because I'd only have one detective that would be available to handle all that. Our detectives are trained, highly trained, in fact, in things that a lot of our patrol officers aren't trained in. And so, you know, for instance, interviewing and interrogation and things like that. And, you know, right now, a lot of our cases that our detectives are dealing with deal with child abuse, sexual assault type cases. There's some major cases as well.
I'm going to object at this point. We're getting a little off the mark in terms of the dissertation.
Well, it's objections overruled, but I would ask you to keep the questioning in line with the scope of this hearing, Mr. Wood.
Okay. So Chief, just to make sure we understood what you were saying, is it your testimony that it would cause a hardship for the detectives department if they were subpoenaed for a significant amount of time out of their jurisdiction?
Absolutely.
Okay. Are you aware, does the Rexburg City Police Department work with and coordinate with other law enforcement agencies in the area?
Yeah, we work with Fremont County, Madison County, Jefferson, Bonneville. We're on a critical incident task force, so we help our detectives go to those critical incident task force clear down to Pocatello at times, as well as helping on other cases when we're called upon.
Okay, thank you. The state has no further questions at this time.
All right, cross-examination, Mr. Pryor.
So how would I address you, officer? Would I address you as sheriff, or what would be your police
Chief.
please?
Chief of Police.
All right, I want to show due respect. Chief, with all of these agreements with the other counties, we're assuming, aren't we, that all 5 of your detectives will be testifying at the same time, right?
I don't know.
Right.
Yeah, I'm guessing they wouldn't all be testifying at the same time. but
Okay. All right, thank you.
When would they be called up? I don't know.
Okay, well, if one of them were called one day and then went back home, and the other one was called a different day and then went back home, and then another one was called on a third or fourth day and went back home, and a fifth one was called on a day and went back home, is it possible that you could get help from Bonneville, Jefferson, Madison County, Fremont County, for each of those 1 days for an additional law enforcement officer to help you while the one officer is testifying, or even two? That's possible, isn't it?
Well, it's not as easy as that. It's not like I can call in one of the other detectives to come in and handle one of my officers' cases that they're working on.
Well, it may not be working on the cases, but if there's necessity that there's some patrolling or other things to do, it's not going to impact a case if a detective is taking a few hours off from a case and has to take a day off and then work on the case the next day. You'd agree with that, right?
Yeah, if I was just missing one detective for a
Right.
day,
So spacing them out or accommodating your schedule with your detective so it doesn't have an impact, that's something that's a viable alternative, isn't it?
it would depend on how far they've got to travel.
Okay, all right. Now, I'm a little concerned. Obviously, you have detectives that are within your organization that are involved in this case, right?
That is correct.
And they obviously can't be concerned with providing security for Ms. Vallow. She's in the Rexburg. Is she in Madison County, or is she under your supervision with Rexburg?
Neither her or Chad are under our supervision.
They're under Fremont, but they're housed in Madison. Well, not anymore, is she? So I guess my question is this. Well, Judge, I'll draw back on that. I'm gonna save that for a later day. I don't think I have any more questions, Judge. Thank you.
All right, any redirect, Mr. Wood?
Not at this time, Your Honor. No.
Okay, thanks, Chief Turman. That'll conclude your testimony then. Thank you for your appearance this afternoon.
Thank you, Your Honor.
You're welcome. You can log off of the call. Mr. Wood, do you have another witness to call?
No, the state has no other witnesses.
All right. Does either side have any additional evidence or witnesses to call before we get to the argument section of this hearing? Mr. Pryor, starting with you.
Judge, I would just have argument.
All right, Mr. Wood.
No further witnesses.
Okay, we'll consider the evidence presented then. At this point, I will allow argument. It's your motion, Mr. Pryor. If you'd like to make argument, and then hear from Mr. Wood after that.
All right, Judge, I would start out, and we're cutting out a little bit, so my hope is that the court can hear me still. Okay, thank you. Judge, I would start out, but I want to cite the case of Irvin versus Dowd. And the case is 366 US 717. And it's a case that I think is directly on point as it relates to a change of venue. This is a rural community, and the case of Irvin versus Dowd talks about the inherent prejudice when you have a very small rural community. And I think in the Irvin versus Dowd case, they were talking about something that's probably 5 or 6 times bigger than St. Anthony. But in that particular case, Judge, they talked about the prejudice that's inherent when there is such media saturation to such an extent that everybody knows about the case, everybody knows about what's going on in the case, and that the very nature of that excessive and unrelenting publicity causes an inherent prejudice for a defendant to get a fair trial. And I would ask the court to take a look at the Irvin versus Dowd, because the Supreme Court of the United States has set forth criteria, and it's very specific criteria. It's very specific criteria that addresses under what circumstances does a barrage of publications and information cause this inherent prejudice? I would also like the court to look at it's Riddell versus Louisiana, 373 U.S. 723. Again, it talks about how excessive press coverage causes and deprives a defendant of a fair trial. Now, my concern is this, is obviously in the small rural community of St. Anthony, we have had a tremendous amount of attention brought to this. That attention includes a number of pictures, obviously, on East Idaho News. Those pictures include a decoration of the county courthouse. Now, those decorations of the county courthouse in Fremont County, they came down after I made my bond reduction for Mr. Daybell well over a year ago. And it was only after I made that argument did that come down. Then the pictures on East Idaho News talked about the sign that was on the very front when you drive into St. Anthony. There's a sign in the very front of the city that you drive into, and on that sign, and for many, many months, Judge, and you'll look at the publications that were submitted to the court, Justice for JJ and Tylee. Now, that is a constant reminder for anyone who drives into St. Anthony and sees the publicity that is being presented. Now, again, right after the Daybell bond reduction motion, strangely enough, excuse me, that sign came down. The signs and the advertising at the Madison County Courthouse, and there's pictures of that as well. The pictures in Madison County and the ribbons decorating Madison County also came down. My concern, Judge, is that there's been so much publicity, and you're talking about a rural community, and I think Irvin versus Dowd and Riddell versus Louisiana are pertinent and offer some insight in what the court should be looking at in terms of how you make a decision as to whether or not this publicity has reached that level. There's also a case, Judge, and it's United States versus Rewald, R-E-W-A-L-D, 889 Federal 2nd 836 from the Ninth Circuit. It's 1988. Again, that's something else that touches on the issue of what's appropriate in terms of a significant amount of attention. Judge, when I took on the obligation to represent Mr. Daybell in this particular matter, I had no idea that this was going to garner so much attention. I would suggest that, Judge, other than a case that occurred in Minneapolis, this case has drawn more media attention than any other case that I can think of in recent history. It has been incessant. The exhibits that have been admitted, 1 through 8 of my exhibits, they aren't just a couple of pictures, Judge. They are a significant number of videos. They are a significant number of stories. They are a significant number of posts. And it's overwhelming, the amount of attention this case has brought. Now, I'm not going to say what Mr. Wood's argument is, that maybe I haven't shown enough prejudice. Well, I think that if the court reviews Irvin versus Dowd and looks at the cases I cited, you'll see how the United States Supreme Court addresses this issue of incessant, excessive publicity and how it interferes with someone's right to a fair trial. I would submit to the court that the amount of attention has been overwhelming. Now, on August 4th, we had a preliminary hearing. It was the second day of the preliminary hearing. And on August 4th, Court TV, and I believe East Idaho News, published a letter, and I have included it in the submissions, from President Nelson of the Salt Lake City, obviously the president of the LDS Church. And that letter came out on the second day of the Daybell hearing. Now, I've submitted to the court, and I'm not going to go into the details of what was said in that letter, and I will leave it to the court. But what took place afterwards, Judge, were a number of conflicting opinions about people who felt the timing of that letter on August 4th was inappropriate by President Nelson. Now, I have had a wonderful opportunity, if there's any saving grace in me doing this, is that I have jumped into the task of learning as much as I can about the LDS faith. I've tried to teach myself. I've read many of their books. Chad actually provided me one of their books, and I read that. And I did some research on President Nelson. He has done nothing but live an exemplary life. He has been a pillar And he's been an amazing role model for not only people in the LDS faith, but for people of all faiths. This is a man who has been absolutely exemplary in his conduct. Now, I think that and I'm not going to speak for him, but I think that his motive at that time was to say, listen, let the judicial system play out. The problem is that I don't necessarily agree with maybe his lawyers and the way they drafted that letter, and maybe he needs to look at some other lawyers, but this is not on President Nelson, and I will never disparage him, because everything I've learned about him and read about him is that this is an amazing human being.
Your Honor, I'm going to object on relevance at this point and facts not in evidence.
Okay.
Well, I'll consider the submission of the letter, but I think we're outside of the scope of this hearing.
Okay.
This
So
language.
I think that what President Nelson was trying to do was he was trying to downplay all the attention for Mr. Daybell in this case, but that submission on the second day of the preliminary hearing brought a lot of attention, and it came directly from the LDS Church, the top of the LDS Church. And again, I don't think President Nelson intended what he did was going to cause that problem, and in fact, I'm almost certain of it. But it did bring a lot of attention. Then sometime later, there was a submission, and this was at the request, and Judge, I've included it as part of the exhibits, and it's in the exhibits. If the court wants the date of when those exhibits were submitted, I believe that was on Fox 13 of August 12th of 2020. That should be in the documents that I provided to you. And what that was a letter from Heather Daybell. And I've included the entire letter as well as the media article that was attached to that. And in that particular letter, Ms. Daybell talked specifics, and she said some very unpleasant things about Mr. Daybell. But the concern I had was this, is that in the letter, she talks immediately, one of the first sentences was, at the request of President Dowling of the Henry Fork Stake. And this was also advertised on Court TV. Court TV ran with this story and publicized the entire letter and talked in detail about what was on what Ms. Daybell had said.
Your Honor, I don't want to interrupt Mr. Pryor, but if we are going to be going into these specifics, I'm going to ask that we do it in the breakout room. And he's entitled to argue. I'm just saying if we're going to argue those facts that we've tried to not broadcast, I think that should be done in a breakout.
Judge, and I'm not broadcasting anything. I'm speaking in general, and I'm trying to be as sensitive to everybody as I possibly can.
All right, Mr. Pryor, hold on. There's an objection. I need to make a ruling on that. I am going to sustain that objection in terms that I think it goes beyond the admonishment I've had in terms of the specifics of the exhibits. Those are in the record and will be considered by the court. And I think if you would just refer to those by reference, but without going into the detail in your argument, knowing that those will be considered by the court. So if you'd like to point out or highlight any specific exhibits and how you think those exhibits legally affect this issue, then make argument on that, Mr. Pryor, please.
And Judge, my concern is that's tying my hands in terms of arguing specific facts about these things. But I'll obviously accept the court's admonishment and I'll move forward. So in any event, I would ask the court to take a look at the documents and all of the exhibits that were submitted in regards to Ms. Daybell. I would like the court to take a look at the area that was impacted by Ms. Daybell's letter, and as well as read the article that talks about the scope and the range of where her letter reached and the number of people that it reached. Then we move on, Judge, to the next issue. Now, the next issue is that throughout this proceeding, there have been a number of vigils. Those copies of those articles are included in the documentation that I submitted to the court. There was a vigil, I believe, in Rexburg. There was a vigil that was done in Idaho Falls. My recollection is the one in Idaho Falls brought in several hundred people. I believe there was a vigil in St. Anthony, and there was a vigil in Boise. And the vigil in Boise drew, I believe, 24 people. So it wasn't as well received as the ones over here in Eastern Idaho. But the fact is that there's been the community brought together, and they've had these religious vigils, or however you want to characterize that, in talking about and bringing attention to this case. That obviously brings citizens from all over Eastern Idaho and it draws attention to the case. The next issue, Judge, is we are in a situation, and I'm going to move forward, where we are then having pictures of various businesses in the community selling items of memorabilia. Various citizens in the community, such as a bakery, that in their bakery at a very well-known grocery store in Rexburg are selling cupcakes that have messages that are directly tied to this particular case. And I'm going off, Judge, I apologize, but I'm going off of my slides. My concern is this, is that a combination of the significant amount of media attention, a combination of how the community has brought themselves together to conduct vigils, a combination of letters that have been sent, particularly in the Henry's Fork stake, that have had an impact. And we have no way of knowing when an email is sent out, what's the scope of where that email went to. The combination of people selling memorabilia such as sweatshirts and cupcakes in businesses within Eastern Idaho that directly reference this particular case. A combination of two courthouses in Fremont and Madison County, in which both of those courthouses have put up ribbons around the courthouse that have been posted by East Idaho News. A combination of the number of signs all over the community. Now that's going to have an impact. So I don't see how that's not prejudicial. And when the court looks at Irvin versus Dowd, you will see how the Supreme Court has ruled in that regard. Now, obviously, we're disappointed in the court's ruling as it relates to David Bryant and the survey that was done. But the reality is the results of that survey are disturbing. And the reality is that there has been an incessant amount of attention drawn to this case. And the reality is that what we need to do is get this out of an area where there is such a rural community that has made up their mind, that have, for all practical purposes, Judge, have got on the bandwagon of vigils, merchandising, and a variety of other things. And we need to move it to a place where there's a larger population base. And unfortunately, like many states, there's one large population base, and that's in Boise. And the likelihood is that if we are going to move the case, Boise would be the most obvious place to try to find jurors who either have not made up their mind or have not had a significant amount of attention drawn to this. To suggest that a rural county in eastern Idaho, we can get a fair jury when this thing has been incessantly on the news for almost every day is absolutely ludicrous. And to suggest we can go to Madison County, to suggest we can go to Bonneville County. And if the court decides to move venue and considers Bonneville County, at that point, I am going to ask the court to take another look at our survey and apply it as I don't think it's appropriate that anywhere in the 7th Judicial District, this thing should be heard. My preference and choice of preferences are simply this, Judge. I would ask the court to consider Boise. I would ask the court to then, if the court did not consider Boise, I would ask for Twin Falls. If Twin Falls is not appropriate to the court, I would ask the court as a third choice to go to Pocatello. At that point, I think that we are far enough away. My final concern is this. I have no doubt that Sheriff Lem Humphries is a honorable man. And I think he's a good man. I have only had one conversation. I don't even know if Sheriff Humphries would remember that. We ran across each other on one of the streets in downtown St. Anthony, but I think he made a big mistake. And we all make mistakes. And I think in this instance, Sheriff Humphrey was honorable enough to say, I made a mistake. I posted this on my personal Facebook account, and I advertised that out there with not really thinking through the impact that would have. But the difficulty is when you're the sheriff in a position of authority in a rural community, and you post those things and talk about justice for JJ and Tylee, it cannot help but to have an impact on this community and influence them some way. So in conclusion, Judge, I would ask the court to strongly consider moving this case entirely out of the 7th Judicial District. I think that based on the cases that I presented, based on the 8 folders which contain subfolders of many documents of a variety of forms, it just doesn't make sense to keep it here. And the difficulty is this, is if the court even considers keeping it in the 7th Judicial District, at that point, David Bryant and his survey should be considered by the court, because at that point, we have a survey with legitimate results that says, unfortunately, 82 to 80% have already made up their mind that Mr. Daybell is guilty. This is
I'm not going to object to any comments on the subject of the polls. It's not in evidence.
Okay, and Judge, that's all I have. In conclusion. Thank you.
All right. And that last reference to the exhibit that was not admitted will not be considered by the court, so I won't consider that part of the argument as well. Thank you for the argument then, Mr. Pryor. Mr. Wood, state's argument.
Thank you, Your Honor. Before I get into the legal argument, just a couple of evidence issues. Mr. Pryor, in his documents were submitted and admitted in the metrics folder. There's 2 documents that we'd like to speak about, and I'm more than willing to do that in a breakout room. It's just data, so I don't know that it's objectionable in any way, but I'll leave that to the court's discretion on how we discuss it.
And Judge, I'm not opposed to Mr. Wood bringing up, I'm fully aware of the metrics and East Idaho News' readership as it relates to Boise and Idaho Falls, and I'm happy for Mr. Wood to go into that. I'll be responding though.
Okay, well, if you'd like to, you can, Mr. Wood. That particular exhibit, I don't believe carries any danger of further prejudice, so I think it's fine to review to those metrics or discuss those metrics here on the live stream, Mr. Wood. So if you have any specifics of that you'd like to discuss, go ahead.
So there's 2 documents. They're East Idaho News' user data hits on stories. There's 2 of them. They each have 25 cities. I would note that there's not a single city in Fremont County that shows up in the top 50 cities of hits on East Idaho News stories. The number 1 city is Salt Lake City. The second city is Boise. But we're not actually here to talk about Boise or Salt Lake or anywhere else other than Fremont County today. And there's not a city in Fremont County that shows up there. I think that's important. So last week,
I guess part of what we have to look at there too is the population base. I mean, last I checked, I think Fremont County's got about around 12,000 people. And, you know, when I look at that list, I guess what I'm getting at is number of hits as a percentage of population. So if you've got a certain number of hits in Boise, but there's 500,000 people in Boise, then Fremont County at 12,000 may not show up. And of course, the concern is the amount as a percentage, I guess, of the citizens that may have been exposed. So I'm just pointing that out. I think a factor that must be considered.
And absolutely, I would point out that there's actually in the most recent census, there's more than 13,000 people. And that's not a big difference than 12,000 people, but okay. It is, you know, that's the data. Now, I agree, Your Honor, and quite frankly, some of this data is a little bit murky, but it's still remarkable that in the location of trial, nowhere in Fremont County even shows up in the top 50. And that's all we're submitting that for. As the court noted in the status conference last week, there is a presumption that venue is proper in Fremont County, and that's where the trial should be held. And it's the defense's burden to overcome that presumption. There's 2 types of prejudice when you're talking about a fair jury in terms of venue. There's actual, which we can't talk about because you have to actually try to pick a jury to get there, or presumed. And at a minimum, the defendant's burden is that he has to show a reasonable likelihood that prejudicial news coverage prevents a fair trial. And in State versus Haddon, it's an Idaho case. The court there recognized that most cases of consequence garner at least some pretrial publicity. However, a presumption of prejudice requiring a change of venue attends only the extreme case And there's a test for that. And that test remains whether the trial atmosphere has been utterly corrupted by press coverage. Further, State versus Yeager, it is not incumbent upon the trial judge to find jurors who are totally ignorant of the facts and issues involved in this case. Further, in Yeager, publicity by itself does not require a change of venue. An error cannot be predicated on the mere existence of pretrial publicity concerning a criminal case. Now, Mr. Pryor did predict my argument. Yes, the state concedes there's been a lot of pretrial publicity. The state would note that the state has made several attempts to lessen that. We asked that cameras not be allowed in the preliminary hearing, not to seal the hearing, and that's in another case, but it does bear on the publicity of this case. We asked that not be allowed, to simply lessen the amount. And we noted that there's no right to a camera in a courtroom. The Supreme Court's been explicit about that. Mr. Pryor and Mr. Daybell asked that it be shown publicly. So the biggest source of evidence involving this case, Mr. Pryor and Mr. Daybell asked that it be broadcasted to whoever may want to see it, whether that's in Fremont County or outside of the county. So the court has been very clear. There's factors that this court must consider in determining whether or not the defendant has met its burden. The first, the existence of affidavits or indicia of prejudice in the community. Mr. Pryor has not provided one witness to state that they've been prejudiced. He's not provided one affidavit. The case law is replete and talks constantly about providing affidavits to show prejudice. Not one affidavit has been provided. Not one indicia of prejudice has been provided. Not a single witness. The accuracy of the pretrial publicity. Mr. Pryor has not made any attempts whatsoever to show any evidence that the pretrial publicity was inaccurate. He hasn't put on any witnesses to talk about it. He hasn't indicated it himself. There's no showing has been made. The extent to which the articles are inflammatory, inaccurate, or beyond the scope of admissible evidence. Again, the defendant is on the burden to show that the general public has been exposed to inflammatory publicity, inaccurate publicity, or publicity based on non-admissible evidence. No such showing has been made. I'll just briefly reference the Heather Daybell email, and I'm not going to get into the facts of it. He can't show how many people received it. He can't show how many people read it. He hasn't produced a single affidavit from anyone saying they were prejudiced by it, nor has he produced a single affidavit of any individual saying they're prejudiced by any of the news. The one area where the number of articles, the state does concede there has been an extreme amount of news surrounding this story. However, the court is clear. That alone does not create a presumption of prejudice.
Mr. Wood, though, on the factors the court does consider, I think, though, the amount in and of itself is certainly a factor, I think, that gets considered. I would note there's a case, State versus Hall, which is an Idaho case, 111-827. And that says impartiality may be affected adversely by the quality or the quantity of pretrial media coverage, and goes on to state that when prospective jurors are incessantly exposed to news stories selectively packaged for mass consumption, they may become subtly conditioned to accept a certain version of facts at trial. Such repetitive exposure may diminish the juror's ability to separate information absorbed before trial from information presented during trial. And that cites to another case, State versus Brooks, 103, Idaho, 892. So while there's an argument maybe that the publicity has been accurate, I think just at some point in overwhelming quantity may be something that could lead to that issue discussed in Hall. So I haven't reviewed through all of the exhibits yet to see where we are on that, but I want to let you know that's a concern I do have, is just strictly based on quantity of coverage based on that case.
Well, and it's absolutely within the court's discretion to do so. That, like I said, that is one of the factors, is the number of articles. I would just point out, though, that the case law is clear that press coverage itself does not create a presumption of prejudice. But the court is absolutely correct in its discretion to review the number of articles and the substance of them. And that dovetails with whether the potential jurors were so incessantly exposed to such articles that they had subtly become conditioned to accept a particular version of the facts at trial. And I think there's been no showing today, and obviously the court has those items in evidence. It can review those items and it can make for itself a determination whether or not it's inflammatory, whether or not it's accusatory. I don't know that I've seen a single East Idaho news story that said anyone was guilty or anyone's not entitled to a fair trial. That would be inflammatory. Anyway, I think the court is entitled to absolutely look at that and make that determination. But the facts that have been related are relevant, that the state has seen, and I'll let the court make its own determination, but appear to be true. They're not fortunate facts. They're not good facts. They're not fun. They're disturbing. But accurate representation in the media, absent of showing the prejudice, it should not be enough. And then finally, the length of time elapsed between the pretrial publicity and the trial, and any assurances given by potential jurors themselves concerning their impartiality. This is a little more difficult to look at because we don't have a trial date set. We don't know when trial is going to be, nor do we know what news is going to come in between now and the trial. We don't know if another case is going to come along and blow this one out of the water. We don't know if this case will become the biggest case in the country. So that's difficult for a court to make a determination on that. Again, Your Honor, there is a burden of proof. The defendant is responsible to show a reasonable likelihood that prejudicial news coverage prevents a fair trial. And for that presumption of prejudice, he has to show that this is an extreme case, whether the trial atmosphere has been utterly corrupted by press coverage. I think to get to that point, Your Honor, he has to show some actual prejudice. He has to show, he has to have some witnesses. He has to have some affidavits of people who show prejudice. And he can smile and shake his head no, but that is the burden set out by the case law. And the state will, again, the one thing I do want to point out, there's a lot of talk about the press coverage. There's been nothing that links it just simply to only in Fremont County. It's all over the state. And so I think that's important for the court to consider as well. The hearing today is about Fremont County. And as far as Fremont County is concerned, I don't believe that burden has been met.
All right, thanks for the argument, Mr. Wood. Mr. Pryor, I'll allow you a rebuttal argument if you'd like. Before I do want to address that fact of what's the direct evidence I have about any prejudice within Fremont County itself that's been presented today or that's in the record. And the other issue is, well, not just on that, but why, what would be I know there are some downsides, but why would it not be appropriate to potentially go see if we can get a jury picked? And if that, through the process of voir dire, obviously we can vet out jurors and see where we land. And then if we determine through, instead of the court having to make a determination here based on this, seeing what actually happens when we get enough jurors there to call, why wouldn't we make a try there first before we go through all of what's going to take to move the trial? So those are the two issues I'm thinking about in this decision, if you want to address those.
And Judge, I'll address your first decision about trying to get a jury in Fremont County and then seeing if we're able to do that. The concern, Judge, is in many cases, that's not an unreasonable request. But this isn't any case. This is probably the biggest case in our country right now. And the case involves 6 counts that could cause Mr. Daybell to be given a lethal injection. And what the court is suggesting is that we're going to pick a jury. And oh, by the way, if we're not able to pick a jury out of Fremont County, at that point, then maybe we need to look somewhere else. But the picking of a jury is not just as simple as bringing 100 people in and saying, let's pick 100 people and see if we can find some people to do this. There are going to be, and then obviously the court's going to see these motions, but there are going to be studies. There's going to be questionnaires. There's going to be a lot of effort. And in my past, when I've been involved in significant cases, there have been times when picking a jury has taken a week, has taken 2 weeks. And if the court is going to invest a week or 2 weeks in picking a jury, and then we come to the conclusion that we're not able to pick a jury here, at that point, we then have to find a place to find a jury to pick and go through the 2-week process again. It would seem that's a waste of resources. Mr. Wood seems so concerned about resources that he forgets that this is Mr. Daybell's right to a fair, impartial jury. And even though he's waived a speedy trial, Judge, Mr. Daybell's been locked up for a significant amount of time. If for some reason in several months from now, we're not able to come up with a jury, it's going to be several more months, maybe even longer, before we can get into another jurisdiction where we're going to pick a jury. So the reality of it is this, is that taking a test run and taking a stab to see if we can do it. When you're dealing with a death penalty case, that's not the manner in which you proceed. The manner in which you proceed is you find an appropriate jurisdiction that you know you have the best chance to obtain a fair and impartial jury. And from my position, the largest metropolitan area in the state of Idaho is Boise, the Treasure Valley. Whether that's Ada County, whether that's Canyon County, that's where we are more than likely to find the largest number of people who may not have heard about this or have may not made up their decision. Now, the prejudice and the direct prejudice question, Judge. This court made it very clear, and I had advised the court that I had a slideshow that I was intending to show a number of slides, and I was intending on putting on a significant presentation. This court was not going to allow me to present certain slides and certain evidence. In fact, the court stopped me on the Heather Daybell thing and said, I'm not letting you get into this. Now, isn't that the very definition of inflammatory or influencing?
And to be clear, I'll review that evidence. The evidence is there and you can refer to it and I can look at it for what it is and make that determination. So it was only in expressly relating to it an argument that I curtailed there, Mr. Pryor.
Right. And Judge, if it wasn't so inflammatory, if it wasn't so concerning, we'd be showing it to all the people watching right now. But the reality is there is disconcerting stuff. And Mr. Wood can put in his pleadings, and Mr. Wood, and this is all on the stuff that I submitted, Mr. Wood can do a press conference and announce that he's seeking the death penalty, and Ms. Blake can get on there and speak.
No, Jack, that's a fact, not an evidence, and that never happened.
Well, that's the objection sustained because that's outside of the scope of anything presented at the hearing here, Mr. Pryor.
Well, it's in the evidence, Judge, and it's in the videotapes that have been submitted. So
okay, it's there, then I'll consider it. And
at that point, Judge, you know what? Mr. Pryor hasn't gone on public TV. Mr. Pryor hasn't gone on court TV. Mr. Pryor hasn't gone on Dateline or anything else and done anything like that. But what has happened in Fremont County is Heather Daybell wrote a letter to the Henry's Fork Stake. That letter was disseminated, and the court can read the article about how far it was disseminated. That's a problem for us. That's a problem for a fair trial. And then what did we hear about today? The sheriff of Fremont County in 2020 on his personal Facebook account posted images of the Daybell case. Now, Mr. Wood brought up, well, you didn't mention Chad or Lori. No, he just mentioned Tylee and JJ on it, and then talked about some other things that were posted as part of this. If you're telling me that a sheriff in a county whose job is part to investigate this case and to provide assistance to Mr. Wood gets on his personal Facebook account and advertises out there, you're telling me that that's not going to have an impact? You're telling me that's not going to influence citizens in rural Fremont County? That is absolutely ridiculous to suggest that it wouldn't influence people. Finally, Judge, again, I keep going back to this. Mr. Wood is misconstruing the case law as it relates to venue. Mr. Wood is absolutely misconstruing the case law and what it says. If the media coverage is so great that it inherently is going to influence the outcome or attention brought to this case. That's in case law, that's addressed in the Hall case that the court brought up, but more importantly, Judge, it's addressed in our highest court in the United States, the U.S. Supreme Court. And they have clearly set forth the standards, not the standards Mr. Wood would like you to follow, but the standards that all of us should be following. Judge, I've been doing this for a little north of 25 years. I have never seen a case that has brought on so much attention. I have never seen a case, and the court can go back, and I can't even imagine the task this court has of having to go through all of the evidence that I've submitted. Many, many items of evidence that this court's going to have to sift through, and it's a huge task. It's a monstrous task. It was a monstrous task to go through all of the stuff for me. I can't even imagine. But Judge, if it's that big of a task, that would suggest that the media attention has been significant, more than significant. It's been outrageous. And it's not a coincidence that in Idaho Falls, Idaho, now I don't want to misstate how far St. Anthony is from Idaho Falls, but these folks in this side of the state have their very own news agency, East Idaho News. This is a very prominent news organization. And whether I agree or disagree with everything that they put on there, and obviously I'm not going to make a public statement, but I don't agree with what's been said about Mr. Daybell. In fact, most of it I disagree with. Almost all of it I disagree with. And unfortunately now I've broadcast that. But that's not the meter that you go by. You apply the Irvin versus Dowd in the cases I applied. And there is no way that with the amount of tension that Mr. Daybell could get a fair trial here. And the difficulty is, it's not let's like shoot basketball hoops and hope maybe we could sink a few and get a fair jury. We don't get to take a try and say, well, let's take a stab at it. And if it doesn't work, well, we'll move it somewhere else and take another stab. That just doesn't make sense. So I would encourage the court to please, this needs to be in the western part of the state, in Boise, Idaho, in Ada County, and that would be the best chance we could get for having a fair and impartial jury.
Okay, thanks for the argument, counsel.
Your Honor, I don't want to re-argue anything.
I was going to say, Mr. Wood, if you have any additional argument, you may.
All I wanted to say, Your Honor, the state just really, the way that Mr. Pryor has discussed Sheriff Humphries, we strongly disagree with. He hasn't cited any law, any rules of ethics, or anything else that he's done wrong. And the way that he treated him as a witness and the way he spoke, we just strongly disagree with, and we'll leave it at that.
And Judge, if he's going to make a statement, then I want a response. Sheriff Humphries acknowledged.
No, Mr. Pryor, listen, he testified. I gathered the reason for the testimony. He made his answers. I'll take that under advisement. I don't need further argument to construe what he said or what he did. So I'll consider the matter submitted in terms of both argument and evidence. So the court needs to review through the evidence, obviously, that's submitted today. I'll issue a written decision on the motion to change venue, which, again, to be very clear, does not actually change venue of the case. It's a transfer of trial under Criminal Rule 21 and also under Title 19, Chapter 18 of the Idaho Code. So I will take it under advisement, get a written decision and determination on that, and that will conclude the hearing. Counsel, while that does conclude the hearing, there's one other matter I wanted to take up separately as it relates to a motion that's been sealed. And while I have counsel on the line, I just want to briefly address that. So we will conclude this hearing on the motion. And then if we could just briefly go into a breakout room for a moment with Mr. Pryor and the prosecution and the court reporter, I'll address the issue related to that other motion, and then we'll be in recess for the day on the case. So Madam Clerk, if you'd set that breakout room up, then we will talk further there.
This county, come on.